begin. We have 2 minutes for the opening. We'll answer some questions, fill questions, and then 2 minutes for the closing. We'll start with Mr. Moore.
Thank you, Sergeant. I've had the privilege and honor of standing with you for 26 years as a prosecutor. I believe in 2001, when your organization began, we met at a church down in South Cobb, and I was on the program with Judge Bridget Campbell and Judge Botiford, and I was honored to do that, and I've been honored to have been a part of your yearly meetings ever since. I'm proud of that association, proud of the work that you do for our community. As I said, I've stood with you for 26 years as a prosecutor. My entire legal career has been as a prosecutor, first as an assistant district attorney, prosecuting narcotics and organized crime cases for the MCS unit, as the chief assistant solicitor, and for the past 16 years, standing side by side with you in your cases in the Solicitor General's office. Over the course of this campaign, a lot has been said about my integrity, about my work ethic, and about the work ethic of my assistant solicitors. I can tell you we have one of the best offices in the state. We have over 100,000 cases a year. We have 3,000 cases per assistant solicitor, and some has been made about the number of cases that we take to trial each year. I can tell you who has more influence over when a case goes to trial, and that's a defense attorney like my opponent. Because you'll get something prepared, it will be ready, and they'll plead at the last minute because they want to see to make sure that you've got your case there and ready. My people don't sit in their office, they're in the courtroom every day. And I'm there to lead them and to guide them, and I'm proud of each and every one of them. And as I said, I've stood with you, and I will continue to stand with you. I hope for your support on May the 20th. Thank you.
Thank you, Mr. Morgan. Ms. Yeager.
Thank you for hosting this forum tonight. I was proud to have my first job as assistant solicitor right here in Cobb County. And on that first day, what I did was walk into the courtroom. And I've been walking into the courtroom every day ever since. And why is it important to go to the courtroom? It's important to go to the courtroom because police officers who make cases need to feel like the prosecutors are supporting them and the decisions they made when they're risking their lives on the side of the road every day. And the difference between Mr. Morgan and myself is that I go to the courtroom every day as a prosecutor and every day as a defense attorney. Prosecutor's job is to be in a courtroom and prosecute cases. It's not just to make plea bargains. When officers make cases, they need to go on the stand, they need to testify, they need to work together with that prosecutor to ensure our police officers are the best and the brightest in this county. 30 cases a year for an entire office being tried is not acceptable. There are over 250 potential jury weeks per year, and if you're only using 30 of those weeks to try cases, and that means only one case per week when more than one case can be tried, then that means something in the process has failed. If you know that something in the process has failed and you're the leader of the office, it's your job to figure out what's going on. Go to that courtroom yourself and ask those questions. Go to the motion hearings. See what's happening. And if you're not going to try cases, then don't bring the jurors to the courtroom. It costs taxpayers $25 per day per juror to come to court and wait for the prosecutor to decide whether or not they're going to try a case. And 100 jurors are called in every Monday. If you're not going to try cases, then tell the jury administrator ahead of time and not call them in. But stop paying our tax dollars for jurors to take time off from work and come to court and do absolutely nothing.
All right, we're going to move on into our questions now. We'll start with Mr. Morgan for the first question. How would you feel about diversion for DUI offenders under age 21?
I wouldn't start a diversion program across the board for underage offenders for DUI. I think it sends the wrong message. I think when you've got a young offender, you need to make sure that they understand that there's consequences to their actions, because if they don't, then they're simply going to go down the wrong path. Now, does that mean you don't have compassion and you seek justice in each and every case? Sure you do. If you've got a .02 DUI and there are circumstances that are extenuating, maybe you find an alternative resolution to that case. But if you've got an 08 DUI offender, you don't want to divert that case if they're under 21. My opponent has said she believes there should be a one free shot for all first-time DUI offenders. I don't believe that, because I don't think that's the right way to go.
Okay. Ms. Yeager, same question.
Diversion programs are not appropriate for a DUI offender, and I've never said that a DUI offender should be given a diversion program. An alternative prosecution, by the way, is a diversion program, which Mr. Morgan has stated that he does for underage DUI offenders. What needs to be done in light of the felony code sections that allow for conditional discharge and diversion programs for first-time cocaine offenders, we need to work with our state legislature and create a conditional discharge plea, just like underage possession of alcohol and just like the felony drug offenses and the first-time marijuana. That way, not only do you teach the under 21 offender the responsibility of having to deal with a case in court by making them go to their community service, providing them alcohol and drug counseling, making them amenable to their actions, you allow them a way for it not to haunt them for the rest of their career, whatever it may be. Because these children are our future lawyers, our future doctors, our future politicians. They need that opportunity. But it's not a diversion program where you're out and out dismissal. Our prosecutor in this county needs to work directly with the legislator to create laws that protect our youthful and first-time offenders.
Okay. We're going to move on to the next question. Starting with Ms. Yeager. If elected, describe to the audience what a typical day for the Cobb Solicitor General would look like.
A typical day for the Cobb Solicitor General, what it would be that I am the first person in the office every day. The next thing I would do is go to the courtrooms and make sure everything is working properly in those courtrooms. And if that courtroom is too busy, not be afraid to pick up a traffic citation and ask a defendant, how do you want to plead on this case? Because that's what a prosecutor's job is to be a prosecutor. Then I would go back and make sure the administrative duties are taking place. I would also, in my jury trial courtrooms, make sure if it's a jury trial week, that we're actually trying jury trials. And if need be, I'd be in the office trying those cases myself, especially those vehicular homicide cases. Then I would attend to the administrative duties of the office, which would include going over the budget, making personnel changes, whatever needed to be done. But the first and foremost duty for any elected prosecutor is to be a leader in the courtroom. Because if you're not a leader, then your assistant solicitors are not going to be either.
I do have to correct one thing that my opponent said, and it was recorded last week. She did use the word diversion for underage DUI offenders, and it's been recorded. Now, as far as what does the typical day look like, it's the typical day that I've done for the last 16 years. There are some 75 to 80 emails every day that I have to respond to. There are meetings with my management team to make sure that everything's flowing like it should. There are individual meetings with the assistant solicitors on cases that they have coming to court. And yes, I go to the courtroom, and I do go through the courtrooms to see what's happened, and I have, in the last 16 years, picked up a file and talked to a defendant, unlike what my opponent is trying to make you believe. There are also boards that you have to sit on. You have to be on the Elder Abuse Task Force, the Underage Drinking Task Force. It is a much more complex job than simply picking up a file and going to court. If you're taking one case, a misdemeanor case, unlike the DA who has a felony, but if you're taking a misdemeanor case, I'll tell you what the defense attorneys have said to me when I've done that. Why are you picking on my client? It makes the jury look like my client has done something worse than someone else.
All right, next question, starting with Mr. Morgan. How closely would you work with the police and victims of crime?
We work extremely closely with the police department and victims of crimes. Just 2 weeks ago, we had a training for new police officers with a DUI task force to tell them how to better try DUI cases. I think if we were doing a lot of the things and not having the contact with the police department that we do, I wouldn't have the endorsement of the Cobb Fraternal Order of Police. I wouldn't have the endorsement of the former Chief of Police, George Hatfield, the Sheriff Neil Warren, the former Sheriff Bill Hudson, the three former district attorneys in this circuit who all worked with my opponent but chose me as the right person to be in this job. We have a close relationship with the police department, and we are constantly out there talking to them, trying to make sure that we're accommodating their schedules with the court schedule, and I believe we will continue to do so.
Same question.
Well, I think the relationship with the present solicitors have with the law enforcement is reflective in the over 15 not guilty verdicts that they've had on DUI and battery cases since January of this year. Since I started my campaign, the prosecutors have started trying cases, but what they found is if you aren't continually trying cases, you're going to lose them. Because those officers on the street that make the cases need to come to court. They need to be with the prosecutors. They need to learn their search and seizure law. They need to learn what the probable cause law is. And that happens by trying cases and by experience. The solicitor's office needs to go to those officers. They don't need to come to them. They need to be at those police precincts, riding with the police officers, watching them make cases, and learning what they do on the field. That's what we did when we started in the solicitor's office all those years ago, and that's what we need to go back to. If we want an effective police force, we have to have effective prosecution.
All right, thank you. The next question, we'll start with Ms. Yeager. Sometimes plea deals are made before making a final plea deal. Would you talk with the investigating officer?
Absolutely. Every time a DUI case or any type of case is going to be reduced or dismissed, I think you need to communicate with the law enforcement. The difference between when I started in the solicitor's office and now is we have email. How easy it is to send an email to a police officer and get a response back. That's absolutely important. And they need to be, their input has to be taken into consideration. We're not going to have police officers who have morale and want to do their job if every time they make a case, their cases are dismissed and reduced. The record shows that of 2,500 DUIs that were made last year, almost 40% were dismissed and reduced to reckless driving. What kind of a message is that saying to our DUI task force?
Mr. Morgan?
We do that. We have a policy that before you reduce a case, you speak to the officer involved. We may not ultimately agree on what the resolution should be, but I think it is incumbent upon us to do that, and that is the policy of our office. Now, I'm not sure where my opponent has gotten her records from, but I can tell you this, that maybe she doesn't remember that when you accuse a DUI, you accuse it multiple ways, and that when you enter a plea of guilty, that you have to get rid of all those other counts so that GCIC will have closure on those counts. So perhaps some of the dismissals that she's talking about are the alternative DUI counts that we've been dismissing. We're nowhere near 40%.
All right, one last question. Mr. Morgan, who are your stakeholders?
Stakeholders are the citizens, the victims, and the police department. And we work very closely with them. We have an excellent victim witness unit who are constantly working with police officers to make sure that we get them to court so that they get the sleep that they need, so that they're able to come to court, and we try to get them away from court when they don't have to be there, when the case has been resolved. So we have excellent victim advocates who work also with our victims. We've got a Spanish-speaking victim advocate who works with that community very, very well. And, of course, the citizens who expect us to do the great job that we've done over the past 16 years.
Same question, Ms. Yeager.
The prosecutor works for the people. The prosecutor represents the people of this county. Whether you're a victim, whether you're a defendant,